yourself a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Oh, just do what text says and just get a real, live, good lawyer. David Whiting, good morning to you.
Good morning, Virginia.
Did you have homework from last week?
No, I had the week off. Did absolutely nothing.
Absolutely
Spent the
nothing?
weekend with my feet up.
Before we do this, just tell me one quick story. And make it anonymous if you have to. But the most extraordinary thing you have been told this week, in the last week, by a client. The most amazing, you are kidding me thing that you've got for us.
I play a little bit with... the bit that got me during the last week was something I actually spoke to you about last week, about what happens if you forget to tell Vicroads you've shifted address.
Yeah.
And in this particular case, I had a client who lived in property A, moved to property B. There was a mail redirection put in place, moved to property C, no mail redirection. Right? And all of a sudden he finds he's got no driver's licence because 2 cars registered in his name, his partner got the extra points. He's now... And then because they used camera recognition or traffic plate recognition on police cars now, he got picked up because a car registered in the name of a person who shouldn't be driving. He didn't know because he didn't tell anyone. And the process for getting those things fixed is just long and involved.
Wow.
And expensive.
So what's the moral of the story?
The moral of the story is please tell Vicroads when you move.
Yeah.
In fact, you've only got 14 days to tell them.
Gee, that's short.
Yes, it's much shorter than I thought. And while I was looking at it, there's a list of what they call personal particulars,
Yes.
which is the information they're entitled to collect on you.
Yes.
And when you change them, you've got to tell them within 14 days. So change your name.
Okay.
I didn't realise until I read the regs that they're also entitled to your email address and your mobile phone number.
Can you do it online? Do you have to do it in person?
You can do most of it online.
Okay, great.
Yep.
Which means not waiting a long time on the phone.
No.
As I had to when the bank informed me that there'd been suspicious activity on my card. Want to know how many hours I waited on the line for the wretched bank to pick up?
That's all. Well, I tried last night to fix the MyGov ID.
Oh, God. You went down a MyGov rabbit hole.
Yeah, I went down the
bless
MyGov.
you.
And I would uninstall and have another go, and it says, we can't verify your identity, and you then ring them and they say, wait times are over 30 minutes, go and read the email. Go and read the websites. I've been reading the website for 3/4 of an hour, that's why I rang. Anyway, not fixed yet.
Not fixed yet. 1300 222 774 if you'd like some legal help. Ian in Geelong, go right ahead. Good morning.
Morning, Virginia.
Good morning.
And so my question is regarding a traffic infringement where I was cautioned by the officer that the discussion was being recorded. On-the-spot fine was issued with an incorrect statement. Now, I've applied for a review of this. It was rejected by police. I also note that police have an obligation to provide a copy of the recording within 7 days. This has not been done.
Certainly if you give a warning, they don't... Not every interaction gets recorded, not every interaction is discoverable, but if you've got given a warning, you're entitled to a copy.
Yes, the officer was very clear that the recording was happening and I needed to be aware of that. I've applied... lodged a complaint request because the copy of the recording hadn't been provided within 7 days, and I requested a copy of the recording. The request for the recording has been rejected by police because I sought a review of the infringement, and that's their quote. How do I get a copy of the recording? Because what the officer wrote down was incorrect.
That is what he's put on the infringement notice is something that isn't correct?
It is incorrect. He actually tried to bully me 3 times during the conversation.
Then why don't you take the matter to the magistrate's court and deal with it there?
I need the recording.
Well, but I would be asking for the recording as part of the magistrate's court process.
Okay.
And that way you're getting your concerns aired in a forum that's not internal to the police.
As part of the so-called, we don't say discovery process, do we? But that they will have to bring that. They will have to show that to him.
You would actually make a requirement. You'd get an order if you needed to in the magistrate's court that the recording be produced.
All right.
And so you would also write to the informant requesting that the recording be preserved as you were taking the matter to the magistrate's court.
All right.
See what happens.
Ian, I hope that's helpful. Thank you so much. Andrew's called in from Essendon North with a particular query. Andrew, good morning. How can we help?
Good morning. My question is, in the instance where two siblings inherit their parents' house but don't agree on whether to sell or for there to be a buyout? What are the legal options for the
Andrew,
other sibling, please, David?
are the two siblings the executors or the beneficiaries?
Beneficiaries.
And has the property been transferred to them?
Well, this is hypothetical. It's nothing.
Okay. Well, it kind of depends on the wording. So, if it's you appoint X to be the executor and I leave all of my assets to my two children, then you're entitled to say to the executor, I want the money, not the box. So you can insist at that point on a sale. In the event that the property, I devise my property to my children A and B, then you take the property and at that stage you look at they're called the partition provisions. There's a process in the Property Law Act for the disposal or the forced disposal of co-owned assets. So it's possible to force a sale. So it really depends on where you are in the system and what the structure is. So if the will says turn the assets in the estate into cash and give my kids half each, you say to the executor, I'm insisting on a sale. End of discussion. If I devise my property to my kids, then you can't refuse to take the property, but at that point you go to VCAT with a request that the property be sold. Does that help you?
Yes, and if just one slight complication, if it might be the case that one of the siblings has occupancy and some control through a member of their family, and therefore refuses to sell, does that complicate things?
It complicates things, but it doesn't change the answer. What you might end up with is an application to the Supreme Court to fire the executor for not doing the job properly.
All right, thank you. So VCAT.
Well, no, you're a long... I take it this person isn't even dead yet.
No.
No. Oh, well, hopefully this is a very much a hypothetical question and not something you need to address. So ring me back when the crisis happens, will you?
All right, but I hope
Thanks,
that's
Andrew.
helpful. In the meantime, you can perhaps prepare a little bit and maybe have some sensible conversations now. 1300 222 774. We've got a similar situation. Chris in New South Wales has a dilemma. Hi, Chris. What's going on?
Oh, hi there. Thanks for taking my call. For 2.5 years, I've lived with my now 91-year-old mother in her home, and I had to decline a job offer to do so. But in any case, she's now in a local aged care facility, and I still look after the property. It's fairly large. And
is it a house or a farm? Is it a property or a house?
It's acreage.
Okay.
Acreage, yep. I guess. And my brother and sister, two of my siblings, they want me to vacate. So they
Who are your mother's attorneys?
I'm a co-power of attorney along with my older brother.
Yes.
I'm also the co-executor in her will, not that she's passed yet. But
Chris, the question from your perspective is what's in your mother... As an attorney, you've got to act in your mother's best interest. Is your mother's best interest served by you staying in the house? You see, you started by saying, I gave up a job so I could continue to stay in my mum's house. That's slightly different.
I gave up a job...
Right? If it's I gave it up to look after my mum, that's different, right? But you have right here and now, your mum's not there. She's unlikely to return.
That's correct.
Objectively speaking, what's in your mother's best interest, and that will determine where you go from there.
Oh, okay.
Right. So if you're logical, if she's never coming back, why am I keeping it? Is the question you need to get to.
When perhaps the proceeds of a sale could fund where she's living at the moment in a nursing home.
Oh, yes. We have no problems with that.
Okay.
It's just somebody's getting anxious, I think.
I understand, but you're an attorney. You've got to do what's in your mum's best interest, and if there is a logical reason for the maintaining of the property in her name, there might be capital gains tax issues, there might be all sorts of issues, But look at it from your what's best for my mum, not what's best for Chris.
Hope that's helpful, Chris.
Yeah, thank you very much.
Thank you. Go and do the right thing. Good on you. 1300 222 774 is the number. I think we're dealing with a number of beneficiaries issues this morning. They come in threes.
They do, don't
they?
Yes.
Margaret in Richmond. How can David help? Margaret, good morning.
Good morning, Virginia and David. Simple, I hope. A friend of mine has recently made a will and now wants to add 2 bequests, simple monetary bequests.
Yes.
Can that just be written at the bottom of the will?
Oh, please, no. In a million years, no.
Okay.
There's a document called a codicil.
Yes.
And because the law was created when everybody handwrote everything. So we had a will, and if we want to make a little change to the will, we do a codicil, and it has the effect of republishing the will with the amendments. Now, you can get a kit for a codicil from a newsagent. You can get a pro forma codicil from thelawhandbook.net.au, or you can go back to whoever it was who prepared the will and say, I want to add 2 bequests to the document that you've already got in your word processor. What's it going to cost?
Okay.
All right. I think the last one is the best one, but one of those.
And when you fill out the codicil, does it have to be witnessed and signed and all that kind of bizarre?
Like a will. So what you're saying is, I, Margaret from Richmond, declare this to be the first codicil to my will dated the 1st of July 2022.
You said first. You actually can add a number, can't you?
Oh, there is no limit to the number you can
I know
have.
someone who's a big fan of adding codicils. I rolled my eyes when you used that word. Oh, I know of dozens of codicils that have been appended to a will. The will won't make any sense in the end, I've decided, after all these codicils.
Oh, okay. Well, that sounds fantastic.
Doesn't it sound like fun?
It's like a lawyer's party, really.
Shall I hand this one on to you?
No, thank you.
No,
Perhaps
not
to
at
make
all.
a new will.
Yes, make a new clear will, exactly. Margaret, I hope that's helpful. Good morning. No, they actually come in 4s, not in 3s, David. Celia in Malvern, good morning. What's your question?
Hello, Virginia. Hello. Yes, my 2 favourite people in the whole world.
How lovely. Thank you.
Look, I'm worried about your social sense, Celia. I just hope it's more than
I'm
us.
not. I think Celia's got excellent taste.
Well, I understand that, but okay, all right.
Now, regarding a testamentary trust I had made when my children were minors, and my brothers were executors in that, I want that changed to the executors to be my now adult children, but my solicitor is quoting me thousands to do that. Is that normal?
I wouldn't have thought so, Celia. You could use the codicil if you wanted to. See, you're actually talking about a will that contains a testamentary trust.
Yes.
And you're saying, effectively, I like everything, I just want to change my executors.
Yes.
You could, if you wanted to, do that by codicil, but what the lawyer is saying to you, well, it's a 20 or 30-page document. There's a fair bit of work involved in that because I need to go through it and make sure it's all right. And that's what the bill is for, or the quoted fees are for. Or you might say a codicil that says, where in my will I appointed A and B, I now want C and D.
Yes, which wouldn't cost me $5,000.
Unlikely, very unlikely.
Right.
Why is this? Thank you. Thanks, Celia. I hope that's helpful. Why is this lawyer gouging so much? Is this common, these gouging fees? They're not gouging.
You and I don't know. I know Celia's our best friend, but apart from that...
Yes.
She's got what is probably a 30-page will. And what Celia has said is, I want the same will, I just want these words changed.
I'm just wondering why the fee.
I would, if it was me, I'd want to go through the 30 pages.
I see.
Because I pick up some responsibilities as a consequence of preparing for it. And rather than just it's a 2-page will that says I appoint A and B and I leave everything to my kids.
See.
Yep.
There actually is obligation on the person who's taking on the job to make sure they've got it right. Fair enough.
And it may not be on his word processor.
It may not be. I've got a couple of lines free. That never happens. 1300 222 774. If you don't have any legal problems, good on you. If you do, David Whiting is here to help you this morning. Frank in South Melbourne. Frank, I think you've got some tree roots problems. Good morning. Go ahead.
Good morning. Yes, that's the crux of the matter is the English plane trees, which have been removed when I was a lad and now put back again. I'm 85, so I've got a long history of the residence. And the fact is that the roots of the plane trees are now digging up the sideways of our houses. I've had professionally laid brick pavers, which are starting to lift, and
Yes.
and up the street from me, 2-3 doors ago, the poor woman's house is being the driveway is completely demolished. Its roots is probably
yes.
yeah. Anyway, the council deny that they have any obligation to do anything about that. Is it? Have they got some special exemption, David?
They have some special exemptions contained in the Road Management Act, but I don't see that it's their tree roots, and that relates to road and the verge and the footpath and all the rest of it. I just don't see it relates to your trees encroaching into your property. But I will have a look, Frank. If you can last a week longer, I'll tell you next week.
Okay.
I know you're 85.
I'll be very interested, David.
Okay, thank you.
Because I think there is some case law on the matter.
Okay,
Yeah.
I will look.
Good, excellent. I like to give him homework. I don't like to give him a free week off. Given all the money that we pay David Whiting for this segment,
I understand.
I like a little return on investment. This has come in, I think it might be from a police officer. It says, this is after our first call about the recording of the incident and our friend wanting to get a copy of the incident that was recorded by the police officer. You only ever receive the recording of the matter if it goes to court. Otherwise, you have to do it under FOI. The recording is preserved for the statute period for all matters involving the issue of a ticket. What's your understanding of that,
It's
David?
an FOI request when I would have thought that perhaps he needs to make a formal FOI request as opposed to just a request of the informant.
That wouldn't just follow, but our original observation was that it would follow from just taking the matter to the magistrate's court.
Well, that then is a court matter and it's now being preserved as evidence.
Yes, and so you can ask for the copy because it'll be introduced in evidence. Yeah, okay. But you can FOI it as well.
Yes.
Yeah, okay. Good to know. Let me see. Kristen. Oh, I can't grab that one. Yes, I can. Kristen in Cheltenham. Go ahead, Kristen. Hi.
Hi, Virginia. Hi, David. Thanks for taking my call. I have an interesting one. Just wondering if I can question something with a charge relating from being admitted into emergency department. The first time I got admitted, this was from cancer treatment. I needed some treatment in emergency department and then did get admitted as a patient.
Yes.
Then 3 weeks later, with chemotherapy, needed admitting again into emergency department and again got admitted in for a few nights. Now, it was over a month later and then I received a charge from the first occasion, and that was a charge to see the doctor, which was about $340. So I found that interesting. I called up my private health. They said, no, we don't cover this because you are an outpatient, which I then found a very grey area between what's deemed outpatient and inpatient.
Okay, so what's happened is that, I mean, it's technically not legal to offer medical insurance, but it's legal to offer hospital insurance. So as an outpatient, you don't get the cover, but as an inpatient, you can claim on your health fund. I am presuming that at some point along the line, the doctor that you saw in emergency treated you as a private patient, not a public patient.
Because you wouldn't get a bill if you're a public patient, correct? No, exactly.
No.
Yeah.
So it was, is this a doctor that you have seen outside emergency?
No.
So you only saw them...
because I only saw them once in the emergency department.
Yes.
And then the second, I didn't receive any charges from the second time I was in emergency. So this is where I got confused. I also questioned it with the hospital and they said, no.
Nothing to do with us.
Charge.
You saw this person as a private patient?
Yes.
Talk to the Health Complaints Commissioner.
Okay.
Right, and that will resolve the issue. Could you then ring us back and tell us? Because it's got me fascinated. Unless the doctor was called in at your request to look after you in emergency, I don't see that you were attended as a private patient.
Okay. And then my next question is,
just quickly,
and I'm happy to let this go, is because I've paid that charge, it's more about my peace of mind and to understand the process.
Yeah.
Kirsten, same process, so it doesn't happen again.
Yep, let's see what they say. And if you can be bothered, call us back. We would love to know. David in Tongala. Hi, David. Go ahead. What's your question?
Good morning. I've got an 80-year-old friend who has a joint home loan with her daughter and son-in-law. they're now separated, the daughter and son-in-law. She signed papers 14 years ago, has never ever seen any paperwork, and now she's concerned about what the son-in-law might do.
First thing I would do, David, I would do two things. First of all, go and have a look at the title to see who's on title and in what capacity.
Who's got the
house.
title, David?
If there's a mortgage, it'll be a bank.
A bank's got it, and it's classed as tenants in common, I think is the expression.
Next thing I would do, David, would be I would go to the bank and get a copy of the loan agreement, and I would also ask for copies of the loan statements, because I don't know the capacity, and your friend would be in a better position to know what to do next when she's got that information.
Is there any chance that David's friend is going to be refused any of these documents by the bank?
She's a co-borrower. She has every right to the documentation.
And David, your friend is definitely on the bank, on the loan document, on the mortgage document as a co-borrower.
Yeah.
Yep.
Yes.
As tenants in common, it was...
No, that's the title.
Sorry.
Should be on the title as tenants in common, should be on the loan documents either jointly or as a guarantor.
Well, is she on the loan document?
I believe so, but she doesn't have any paperwork.
I understand, but 14 years ago the rules were slightly different. Go to the bank and get copies of the documents.
Okay.
Thank you. And if you're having trouble with that, come back and let us know, because it is possible, David, that she thinks she's repaid money, but she thinks she's on the loan documents and may not be.
No, my guess is that she's not contributed in any way to the loan repayments. The money didn't go to her, went to the daughter and son-in-law. And what I would be interested in from David's point of view is, are they ahead on their payments? What's the amount outstanding as opposed to what was borrowed? I'd want to make sure that, if I could, that I stop the loan getting worse.
Yeah, that's right.
Yeah.
And there's a lot of mystery around this one. You've got to get the documents and you've got to find out. Good luck, David, and to your friend. Mary in queue. We can quickly fit you in, Mary, if you're fast. Thank you.
Hi, thanks for taking my call. I'll try and be quick.
Mary, you have to be quick. I'm sorry.
My husband and I have been together 22 years, married 7.
Yeah, no, see, that's the detail we don't need. Just get to the question.
Okay, we have separated 8 months ago. I live in the home that we shared with our 16-year-old. It is actually owned by his mother.
You have no claim on the house, Mary. That's the answer to the question.
0, so there's nothing I can do.
No. You have no claim on the house that doesn't belong to your husband.
Okay. And so if she passed and it went to him, would I have a claim?
You don't have a claim directly on the house because you effectively don't include inheritances, but his financial resources outside the marriage would be substantially better because he's now picked up presumably a house in Kew worth $1 million. Right?
Okay. Thanks so much.
Thank you.
Mary, sorry to rush you, but there you go. The answer was brief and to the point. Great to see you, David.
Thanks.
We'll see you next week. David Whiting, thanks again, helping you every week with your legal problems.